Walaikum salam. Namaskar, Sat Sri Akal. Good evening, friends. It's midnight, and I appreciate my daughter who's been supporting me the entire day to get these videos in place. This is my 104th video, and this I have shifted from a case from Firozpur to Faizabad. This is a very vital case because after this case, our compensation was ruined. All bungalows are being resumed, and there is a clear ruling that we will not be compensated. Let first part of resumption under clause 6 be done, and in arbitration or the clause 8 part can further on be done. The travesty. Now let's read this judgment. This is a case of Faizabad, and there was an appeal filed by Mr. Harish Anand. Now he very clearly fought this case on compensation. So the civil appeal of number 868 of 1979, date of decision was 26th July 1995. Now whether the only right of the grantee is to claim compensation, and whether the government can take possession at any time after expiry of 1 month in view of the GJO 179/1836. A very important issue was made. Now I will read some extracts of the judgment, and which has to be understood. It would appear that detailed instructions in that behalf were made in the standing order number 241, which was reproduced by the division bench of the Allahabad High Court, in which this appeal as a method of valuation is to be done. Suffix. It is to state in this order 241, though does not contemplate of issuing prior notice to erstwhile licensee. Now where is this order 241? It's very important. Whose license has been determined under clause 1 of grant before determination of the actual amount. The erstwhile grantee is entitled to a notice so that the grantee would be at liberty to place before the competent authority all relevant material for determining the value of building and for payment of amount thereof. It is seen that it is not a condition precedent to determine at the first instance the compensation after giving an opportunity, make payments thereof, and then to resume the property. What is the condition precedent? Is issuing of a notice by giving 1 month, and on expiry thereof the government is entitled to resume the land. The amount is to be determined as required under the relevant provisions given after giving opportunity, and which could be done thereafter. After all, the property would be resumed for public purpose. The determination of value of the building erected is a ministerial act, what is the court is saying, and payment thereof is the resultant consequences. Just imagine, this process would take some time, and if the reasoning of the High Court of Allahabad is given effect to, it would defeat the public purpose. In view of the Delhi High Court Raj Singh versus Union of India, is consistent with the scheme and appears to be pragmatic and realistic. So these two judgments, Raj Singh, finally came to Supreme Court under Harish Anand's case. The High Court therefore was not right in its conclusion that it is a condition precedent to determine the amount of value of the building in the first instance, and payment thereof before resumption of property. Now what do? Harish Anand had expired, his LRs were not there. So what did they do? The LRs then filed a suit. Under that same resumption notice was issued on 19th July 1974, and again held that the determination of compensation by giving 1 month notice and all that was held invalid. You'll be surprised this bungalow owner was given a meager amount of 11,288 as compensation for his authorized built-up stay. Now here the court is reproducing in this judgment, which was by the LRs on this review. It further, the learned single judge of accepted the case on the writ petitioner, respondent herein and held that since the determination of compensation was the condition precedent for resumption, which was not compiled in this case, the resumption notice was invalid. So this is what Harish Anand won in the lower court. So this notice was quashed. Further question arose whether determination of compensation was made following the procedure confirming of the natural justice. Now here where the whole show goes. In this case, we are also of the view that the process of resumption of land, clause 5 grant does not get indefinitely postponed till the dispute as compensation is determined according to law. In other words, the determination of compensation after hearing the affected parties, though mandatory, is not a condition precedent for the exercise of power of resumption. The resultant position that emerges is that the question formulated earlier has to be answered in negative and the writ petition is liable to be dismissed. So the LRs lost, but they didn't give up. So LRs again approached the Honorable Supreme Court in 2010 on the judgment, which is pre-printed on page 591 and 596. Now what relief did they get? They again got the similar relief, that they would be compensated. How, when, not answered. So friends, these kind of judgments when come, they kill us. We are left with nothing. Nobody is interpreting anything of the laws. The court is adjudicating what is coming in front of it. It is only reading in piecemeal the GGO. Can it do that? No, it cannot. You got to read a document in its full text. There's so many things which we can do on it. But I must share one thing with you. The bungalow owner who was resumed by the Supreme Court either is in possession of the bungalow till date, as he filed a suit in the lower court before the eviction proceedings or the possession could have been taken. We have it in the RTI. I have been in touch with the bungalow owner. So my again humble request, united we will fight. If we are broken into parts, into different organizations, today I am using this word, we would be a disintegrated lot. So please unite yourself, because our basic war is one. We are fighting the same system, the same Governor General order. Maybe I am coming through a different channel. The new association which is called some all cantonment welfare association would be is doing the same thing. Get in. I know why people can't get in. I don't want to be blunt on this. But please, shun your egos. Let's get our knowledge together. Because I know most of the people who are on the chairs of those that committee or that organization are all illegal occupants or are journals or commanders, and they've all managed to get their things by the sourceful manners. Why can't you and me do it? We can't. Because sometimes we are not that rich, sometimes we are not that positionally powerful, sometimes we are not having that hierarchy or money. Let's get united. Thank you, good day and good night, friends.